Hey everyone, welcome back to the channel. As you can see, the background has a little European twist today. Yep, I'm in Prague, soaking it all in while waiting for you to finally smash that subscribe button so we can hit 100,000 subs and I can head back home. But enough about me. Today we've got a wild one. An obnoxious defendant who's demanding a speedy trial and more time to prepare for it. Basically, he wants to have his cake and eat it too. And you know that's not going to end quietly. Let's dive in and see how this chaos unfolds.
People of the state of Michigan versus Benjamin Macario Martinez, 237407ST, 226707ST, and 162435FY. Concerning the matters then we were set over from last time, Mr. Downing, in regard to the underlying matters that are left open, has there been any progress?
Your Honor, an offer, I believe, was extended to Mr. Martinez by letter dated June 8th, while he's been incarcerated in the jail. We have not heard what his response is, so I will leave it to Mr. Martinez whether he wishes to enter a plea pursuant to that on the two files he has to that offer or seek an adjournment.
All right, we're also here for sentencing on a number of contempt. So in regard to the two open charges, Mr. Martinez, and your proceeding here today in general, are you choosing to proceed without a lawyer here today?
Yes, I am, Your Honor.
Well, that was mistake number one. And things are only getting crazier. As you're about to see, this defendant insists on representing himself, all while constantly whining about the very disadvantages of doing just that. It's like watching someone set a trap for themselves and then be shocked when it snaps shut.
So concerning the two files that remain open, 6707 and 7407, Ms. Cass apparently sent you another offer after we had court last time. Mr. Martinez, I have no idea what that offer is. The court is not part of any plea bargaining. You have both of these cases here. What is your position in respect to whatever they sent you?
I would like to file a motion to have charges all dismissed due to the Speedy Trial Act. And also, I didn't get, last time we were in court, I expressed to the court that I wasn't able to have reasonable time or inadequate law books. They're old. I only got an hour and a half.
So what did he expect? The court to give him 8 years to go out and earn a law degree? Sure, the Constitution lets you represent yourself, but it also lets you lick windows. Just because you can do something doesn't mean you should, and this is exactly where he's about to learn that hard lesson.
I only know some rules for an hour and a half of studying, so out of my freedom of speech and the rules of professional conduct, I'd like to read my motions.
All right, go right ahead.
For every waste of time and the money of the people and their state, I would like to say this under the right of free speech, and I would like to invoke on my rights, civil and state laws, to state and file motions and to be treated fairly by judge and prosecution, to uphold all the laws that are to be held in the courts, and so as me representing myself can have a fair chance without having rights infringed upon by any members of the court, and I'm doing so. I'd like to file a motion to have all charges dismissed upon my rights being infringed and violated. Due to these reasons, rights to speedy trial and to have adequate time to with representing myself, and in doing so, these are my civil rights and need to be enforced and protected. Not enough time to study, even after motion, or the judge throughout plea, not able to study in a reasonable time having defended myself when it was brought to the court's attention and prosecution. If need to, it's all on court record, transcripts and rights of trial by jury, and adequate time to have my own witnesses.
Are you noticing the contradiction yet? He starts off claiming his right to a speedy trial has been violated, but then turns around and makes a bunch of demands that would require him to waive that very right. It's like shouting about being in a hurry while insisting on taking the scenic route. Confusing, frustrating, and a little ridiculous all at once.
Which are under the time frame, and the prosecution knowingly didn't explain what or help me, which is repugnant and biased by the court. And for also the court saying and giving false advice, and also for my bond being excessive and also biased in setting bond by stating it's more than fair when I was unable to bond out. And when it was amended, I have reasons why 30 days from the timeline of being able to represent myself is being infringed on. And I'd like to have my trial by jurors, and these are the few offhand as to why most of the Speedy Trial Act and also False Pretense Act 774.49, they have to abide by all Supreme Court rules and also rules of professional conduct. Opinion 4, which is federal, asking for help retaining for motion. Prosecutors Rule 3.8, didn't take action or all actions making sure my rights were protected. And Rules 4.3, if they know the law and what I'm saying, these are U.S. Supreme Court, Michigan rules, and 30 days minimum for U.S. Supreme Court 3161-C2 Dismissal Speedy Trial Act 3162 and 3164 1974 18 and discipline of all attorney 3161, knowing I'd never be able to proceed without justification. Rules 3.2, repugnant or imprudent, prejudicing, impartial trial, miscarriage. Also People versus Lehman, stating that I shouldn't be in jail or in prison for fines when able to prove I was unable to meet the court's obligations. And I was also in jail during the time of the one failure to appear.
Oh my God. It just never stops with this guy. First, he demands a speedy trial, then he's granted one, and fails to show up. Normally, when a defendant misses their own trial, the judge has no obligation to uphold that speedy trial right. Of course, speedy trials are a complex matter, and every case has its nuances. There can be mitigating circumstances that might lead a judge to a different conclusion in a similar situation. But watching this play out, it's a masterclass in irony.
I don't think it's very fair that with having to go against people that have 8 years of schooling versus my hour and a half, when I've asked every day to go to the law library and kited, and there's no way that my act to speedy trial, if you need that read, can ever be met. And I got a bunch of federal laws too that if we have to go through all them, why? Or I can write them up in a motion to have more reasons for dismissal.
All right, thank you, Mr. Martinez. Mr. Downing, do you wish an opportunity to respond, or do you want an opportunity to do a written response, or where are you at with that?
That's a very rambling, if you want to call it, motion. I don't know how any kind of speedy trial is impacted here, in as much as one of these was just set for trial and the first trial date was today. He also failed to appear on the other one. He's set for sentencing on that. If he's complaining about legal research, he has a right to a court-appointed attorney to assist him in advising him of all that. I do note the record 2 handwritten responses from Mr. Martinez in response to Ms. Cass's offer letter asking to discuss the offer with her. It says nothing in there about speedy trial or anything of that nature. To the extent that he's setting himself up or trying to set himself up for these objections, I don't think there's any basis for it whatsoever. But if the court would like a written response, we would need a transcript of what he has rambled on about here in order to decide what it is exactly he's arguing.
All right, in regard to the matter, we've spent a good hour and a half or more on the record. I think it was last week, maybe the week before. We went through a whole plea colloquy. We got down to the end. The deal had been made. He decided at the last minute then he wanted to have a trial. So we set this matter over to today's date. He didn't want a lawyer then. He doesn't want a lawyer now, yet you want to complain that you don't have access. You're going up against people with 8 years of education. Which is it, Mr. Martinez? You want to represent yourself or you want a lawyer?
I want to represent myself, and I also was given false information by some court officers that I wasn't allowed to have a standby counsel or have advice by a counsel. And I know there's also a federal law that says that I'm able to have third-party advice. So I like I said, I only got out for 2 days, really, the last 2 days. I don't know how I'm supposed to be able to study upon the law, which I stated last time that the law books are and pages are missing out of them. And I showed guards that last night. Like, there's no way that will have 30 days to be able to study and defend myself from the time of this trial. And it states that there's a federal law and if you want to see the Speedy Trial Act, I have it right here. I can read it off.
Pretty familiar with that. I've been at it about 35 years now.
Okay.
So in regard to the matter, Mr. Martinez, your motions are denied. In regard to your lack of a speedy trial issue, the following is my finding. One, first off, I'm going to sentence you on all of these failures to appear in contempt of courts. Last week, you had the opportunity. I dismissed and purged 2 of them. If you pled on 2 of them, we got through the whole plea colloquy on that, and you didn't want that either. So then we went through the hearings, and I found you guilty of 4 contempts because you failed to appear 3 times and you haven't paid. We're looking at a 2016 case that you still haven't paid on. So this is my sentence. You want to say anything in respect to your failures to appear sentencing before I impose sentence, Mr. Martinez?
Yes, there's federal laws state and that you cannot imprison somebody for fines being unpaid.
And yes, we're talking fines here, not court-ordered sanctions. If the court orders you to pay and you don't, you better have a really good excuse. Otherwise, you could be found in contempt and end up attending all future hearings from a Zoom jail center instead of the cozy courtroom, or worse, from some dumpster behind 7-Eleven. Trust me, that's not where anyone wants to make their legal debut.
And I already told you that I can prove that I wasn't there. You guys know the law. You're supposed to uphold it on both sides. I know that.
I made my findings. You are able to appeal anything you wish.
You gave me bogus
Mr.
information.
Martinez.
You're not supposed to give me legal information. You're not supposed to do that. The only thing you can tell me is I can go by representation or I'm allowed to have an attorney. You gave me bogus laws to look up and information, and you were biased. So there's another reason.
Well, Mr. Martinez, your objections are noted for the record and preserved. In regard to the matter on the failure to appear and failure to pay in 162435FY, I'm imposing 45 days in jail, 23 days of credit on both counts. In respect to 226707ST, 2 failures to appear, 45 days in jail, credit for 23 days concurrently with the other case. In regard to your outstanding cases, the 237407ST, we will set that for trial on July 10th. That'll be all-day trial. That one will come first. And we will set the 226707ST trial for just for a call that day. But we're going to try the newer one first. The older one, he's already failed to appear on it twice. I'm making the following findings in respect concerning Michigan Court Rule 6.004, speedy trial. In regard to the matter concerning Mr. Martinez, bond is set at 1,000 personal recognizance. Actually, it's set at 1,000 personal recognizance in 237407 ST. I don't think I'm going to set that one first then. In regard to the 226707, he has a bond on the failures to appear. He's already been sentenced on those. He's serving time on them now. The underlying bond on the driving charge is, can you pull it up on JIS, please?
On to the failures for the underlying is 2,500 cash or 10%.
All right, we'll set that one for trial first then.
Which one?
The 226707 ST. The newer one has a PR bond on it, so there's no requirements for time on that.
Okay, so there'll be a firm trial date on
July 10th.
707.
Yes, on July 10th. And concerning the matter then, in regard to the court rule, Mr. Martinez has been incarcerated since his arrest on May 25th on all of these matters that were outstanding. The trial is set for July the 10th, which is beyond 28 days. However, at this point in time, Mr. Martinez is, one, serving a sentence, two, has failed to appear numerous times in this trial previously, including several trial dates that were set timely. And the reason that it's not going to trial, for example, I gave him a timely trial date back on April 29th of 22 when he didn't do us the courtesy of bothering to come to court. So I am finding under the court rules there is good cause and clear and convincing evidence that's been demonstrated that he's likely to fail to appear for future proceedings should I give him a PR bond on this case. So for those reasons, I'm leaving the bond in place. We'll set a firm trial date for July 10th. We'll trail the new file along.
In short, his motion to dismiss, denied, case closed.
And if you change your mind about a lawyer in the meantime, Mr. Martinez, you can make the request to the district court clerk. She'll refer it to the Michigan Indigent Defense Commission. They'll decide whether you qualify. In the meantime, the sheriff has the purview of the resources over there. You're entitled to use the jail resources. The sheriff is the one that's going to decide what the time parameters are. I don't have any control over the sheriff. So you can complain. Your record is set. You have made your record. It's all preserved here today. But in respect to the issue, if you really want to have some assistance and get some meaningful legal advice, I would suggest you apply for a lawyer instead of just complaining about it. But that might actually get you somewhere. So I don't know, Mr. Martinez, it's on you. In the meantime, an appeal to circuit court may be taken within 21 days from the date of your sentence, or as permitted pursuant to Michigan Court Rule 6.625B, if the sentence includes incarceration, and if you wish to file an appeal but are financially unable to do so, MIDC will appoint a lawyer for you if that request is made within 14 days after your sentencing. In regard to the issue of trial, I request for jury instructions and whatnot. The pretrial order was released. I sent out a pretrial order last year. Those 10 deadlines remain in place. Mr. Martinez, we'll see you for trial July the 10th.
Yep.
Anything changes in the meantime, you know what to do. Yes, the balance due remains outstanding. Payable commencing 30 days after his release from jail and every 30th day thereafter. And that's $100 a month on that outstanding 2016 case. All right, thanks to the jail. That'll be it on these files.
Alright, that's a wrap for today's video. If you enjoyed it, smash that like button. If not, well, hit dislike and tell me why in the comments. Don't forget to subscribe and turn on notifications so you never miss any of my latest content. I'll see you in the next one.